Yes. Hello, everyone. This is Mustafa. I would like to welcome you from Turkey, from Istanbul, and I'm really happy and appreciated to see that more than 100 people as a participant in our event, which is a kind of flagship event of LAS Turkey. And we will also very appreciated and very happy to onboard three prestigious speakers from different countries, and we will mention about patentability of software and business methods today. And as you know, that LAS Turkey is a Turkish chapter of LAS International, which is a wide range IP and licensing professionals network in a global site. And on the other hand, as LAS Turkey, we are trying to enhance the IP and licensing capacity in Turkey. That's why we are organizing this kind of seminars and trainings related with IP and licensing. And we are really happy to continue our Friday IP Talks, which is our flagship event. And I'm really happy to organize it in English also, because I see that lots of names from different countries, Europe, United States, India. It's really good to see that, to reach outside of the Turkey. And today we have two Turkish speakers and one speaker from Germany, Bastian Best, and I will also introduce them before starting. And before start the session, I would like to say that, and there are lots of IP professionals in the participant list. I see that, and you are welcome to be part of LAS Turkey, and you are welcome to become a member of LAS Turkey to help us, to support us, and to create this IP and licensing network in Turkey, because we need to enhance the IP capacity in Turkey, and we need your power, we need your passion, and we need your expertise. Please consider to be a part of this wide range network, IP network in Turkey, and you are welcome to be members. And before starting, I also would like to say something about our new members of LAS Turkey. We have 4 new members in the last 10 days. So I would like to thank them for becoming our members. Ümit Yontar from Informaskop, Duygu Akşit Karaçam from Hergüner IP Law, İsa Turgut İnci from Yıldız Teknokent, Yıldız Technology Development Zone, on the other hand, and İzlem Şahinkaya from Yıldız Technology Development Zone from Istanbul. So we would like to welcome on board, and we need your support, we need your expertise to enhance this IP capacity, IP network in Turkey. So I see that we have 141 participants. It's a really good number for us, and I'm really happy to reach this number of participants. And also our General Secretary of LAS Turkey, Murat İdal, is welcoming you in the chat site. And so I think we can start to our events. As I mentioned, that we will cover the patentability of software and business methods today. So it is really emerging topic in terms of that we are living in this startup era. So the technology development progress is rising, and the software is eating the world. And in that manner, the software patentability and the business model patentability is a kind of question mark in the technology-based companies, especially in the startups. So that's why we decided to cover this topic with different prestigious speakers from different countries. And I'm really happy to be with Bastian Best. Welcome, Bastian. How are you?
Thank you, Mustafa. Thanks for the invitation. I'm fine. How are you?
I'm really fine, and I'm really happy to see your microphone, because I know that you're recording video sessions and the podcast sessions. It's really good to see that you are pushing the IP expertise in the internet era, right?
Thanks. Yeah, that's what I do. Yeah. I have a little YouTube channel, and I do lots of videos there, and also with all those Zoom conferences and Zoom calls during the pandemic. Yeah, I thought it would be worth to get some better hardware.
Yeah, that's a kind of investment for you.
Exactly.
So you are basically in Munich?
Yes, I'm based in Munich, in Germany. Yeah,
That's great.
exactly.
That's great. How is the weather in Munich now?
Yeah, fall is coming. So I think right now it's not raining, but yeah, it's getting colder. Maybe we have like something like 8 or 10 degrees centigrade.
It's
And
colder.
yeah, rain is coming slowly now.
Exactly. So we are in the sunshine now in Istanbul.
I'm jealous.
Yeah. So our next speaker, the second speaker, is Barış Atalay, who is also another European patent attorney, as well as Bastian Best. Welcome, Barış. How are you?
Thank you, Mustafa. Fine, very fine. How are you?
Good to see you after months.
Yeah, we were away for so many months.
Exactly.
With only online presence.
So where are you now? In Istanbul?
In Istanbul, yeah, in Istanbul.
All right. All right. Thank you so much for your participation.
Be back to Izmir for some time next week.
Next week, before the rainings and the real storms.
Probably.
So our third speaker is from United States, Nevada, Dr. Gökalp Bayramoğlu. Welcome, Mr.
Hello,
Gökalp.
Mustafa. How are you?
Fine, fine, fine. How are you in Nevada now?
I'm fine, thank you. Weather here quite nice, between 20-25 degrees centigrade. So this is
great.
not nice time compared to summer. Yes.
That's great. Thank you so much for accepting, all of you, for your time and for your efforts in this Friday IP Talks. We are really happy on behalf of LAS Turkey. So before losing time, so I think we can start our presentations, and maybe I can mention about the concept of our online event today. So today, each speaker will have 20 minutes presentation time, and they will cover the patentability of software and business methods in Europe and United States perspectives. And also after each presentation, we can receive the questions by your questions, your comments when it comes to your mind. So don't wait until the end of each presentation. Just write on the chat, and then I will help you to raise your question to the specific speakers today. And after each presentation will end, also we can have a wrap up with the other resting question and answers session, and then we will close the session. So I think it will take 1 hour and 20 minutes. Maybe we can exit the time. No. It can be possible. So it is recorded session. I need to make this disclaimer before starting. It is a recorded session, and our speakers have their permission to record our event. And also, as LAS Turkey, we will publish this recording in our YouTube account. So we will let the spreading the IP information with most of the participants after the live session. So if you don't want to show your face, please close your video section. And now, okay, after this disclaimer, we can start with Bastian. Bastian, are you ready for your presentation? Let me make you host, and then you can share your screen.
Perfect. Thank you, Mustafa. Yeah, ready as can be. So I'm trying to share my...
Now you are host.
Presentation. Yeah, now I'm the host. Okay, I hope I don't quit the call.
Yeah.
Okay, so now you should see my slides.
You can also introduce yourself before, because I didn't say anything, because you know you better than everyone. So you have 20 minutes. Stage is yours.
Perfect. Thank you very much, Mustafa. So I'm going to talk about the patentability of software from the European perspective in the next 20 minutes. Okay. Yeah, who am I to talk to you about this topic? So my name is Bastian Best. I'm a European patent attorney and also a German patent attorney. And my focus is on digital innovations. So originally I studied computer science. And I've been a computer guy all my life, basically. So it was only logical to study computer science for me. And then I eventually became a patent attorney. For the last 13 years, I've been working in one of the largest European IP firms in Germany, Badele Pagenberg. And roughly half a year ago, I started my own small patent firm, my own practice. So quite exciting times for me right now, but that's not the topic of today. My topical specialization is digital innovations. So this goes nicely with what we will be looking at today. Mustafa already mentioned it. Software is eating the world. Everyone knows this saying probably. Another one is data is the new oil. And that's also what the European Patent Office says, basically, at least when you look at their PR, at what they put out on the internet, on their website, for example. So they have an own section about digital technologies and what they call the fourth industrial revolution. They talk about that it's no longer about steam or oil, but about data. The EPO even does a whole studies about these topics, patents and the fourth industrial revolution. And when you look into those studies, you see basically all the buzzwords. Data is at the center of the value creation process already today. And we see basically all the buzzwords like digital twins, predictive maintenance, things like that. And of course, AI, artificial intelligence, and machine learning. So one could think that, well, so based on these things the EPO puts out there, they should have a pretty progressive way of dealing with patents for these new technologies. We will see how this plays out then in practice. When we look outside of Europe, there are quite critical voices in recent times. So I found, for example, one article here by one of the large US law firms, Kilpatrick Townsend. And in this article, they say that Europe may have a cultural bias against patent protection of software and AI. And they even say it's probably resulting from the European Patent Office's hostility towards software and AI applications. So very, very critical voices here from outside Europe onto what the European Patent Office is doing here. I'm really curious about what our colleague from the US, whether he can confirm this opinion about what Europe does or not. We will see. Okay, so when we talk about patenting software in Europe, let's have one look into the legal framework. So this is the only slide where I really have the legal text on it, but we have to look at this single article, Article 52, the fundamental article which defines what are patentable inventions in the European Patent Convention. You all, or most of you will know it probably. It basically says that European patents shall be granted for any inventions in all fields of technology. So that's kind of the first requirement we have. There must be an invention in a field of technology. And if there is such an invention, such a technical invention, then it has to fulfill also the, let's say, classic requirements of novelty, inventive step. And we have, of course, industrial application, but that doesn't play a role in practice. So let's focus on these three. Now, the next question is, of course, what is an invention now and what is technical? What is technicality? Well, the lawmakers, the founders of the European Patent Convention decided that they don't want to give a closed, exhaustive definition of these terms in the law, because they thought that, well, technology is evolving over time and therefore the legal framework should be adaptable to future changes. So they did not include a closed definition of technology. But what we have in the law is this paragraph 2, which gives kind of a blacklist, a definition of what is not an invention. in the sense of paragraph 1. And there we have a certain list of items which are per se regarded as not being anything technical. There are things like scientific theories, of course, discoveries, things that are rather abstract, aesthetic creations, and in paragraph C, we have programs for computers. This is probably because when the law was established back in, I think it was in 1973, the European Patent Convention came into existence. People and the lawmakers didn't really know what to do with this kind of software thing, which was coming up then in the beginning of the 70s. So it is now on the list of things that are excluded from patentability, but only, and this is paragraph 3, only as such. So only if you claim one of those items as such, then it is excluded from patentability. Quite difficult legal framework, I would say. So when I first read it as a computer scientist, I was not sure, is software now patentable? Is it not patentable? So what to do? Well, over the years, over the decades even, the European Patent Office and especially the boards of appeal have created case law that has established quite an, I would say, quite a practical and elegant way of how to deal with this more complicated legal article. And this is a picture of the former building in which the boards of appeal used to be in Munich. And the case law basically converged over the decades into two main things. That's the two-hurdle approach and the convict approach. So the two-hurdle approach says that there are basically only two hurdles to patentability for any invention. The first one being that the invention has to be patent eligible. This goes back to this statement, all fields of technology. So this first hurdle of patent eligibility in Europe is pretty easy. You see smiling faces here because it's a very low hurdle. You only need one single technical feature in your patent claim, then you are over that hurdle. Because the requirement is that if the patent claim has technical character as a whole, then it is considered to be patent eligible. And the claim has technical character if it uses some kind of technology. At that point in time, there is no comparison with the prior art. So it can be a trivial feature like a computer, for example. And the conclusion is also that if we are talking about apparatus claims, so claims directed to a device, a machine, a computer, those are automatically patent eligible always because they are directed to a device, to a physical thing, which is a technical entity. So the claim has technical character then. And for method claims, which play a central role in software patents, of course, because you can nicely define the algorithmic part of the invention in a method claim. Such a method claim is automatically patent eligible if you just phrase it as a computer implemented method of doing something and then listing the steps. Only because of the presence of the word computer, the method uses technical means, namely the computer, and therefore the claim is patent eligible as a whole. So long story short, patent eligibility, unlike in the US, we will probably hear about that later, at the EPO, no problem at all. If the patent application is refused on that hurdle, you should probably blame your patent attorney because he has basically done a bad job in formulating the claims. The decisive hurdle is the second one, and that's inventive step, basically. And here we have now the convict approach. The convict approach says that you can have a mix of technical and non-technical features in your claim. And there can even be extreme cases where the non-technical part defines the majority of the claim. But so that's okay. But the non-technical features in the claim as such, so insofar as they do not provide any contribution to a technical problem, they are simply ignored in the assessment of inventive step. So here we have this notion of technicality a second time. The first time at the patent eligibility hurdle, it's rather easy, but the second time we encounter this requirement of technicality, it's more serious, because here you can base your inventive step analysis, your argument why the invention is non-obvious, only on the technical substance of the claim. Let's call it that way. So that's the legal framework at the EPO, quite slim and quite practical, I would say, but there's also kind of a circular reasoning, of course, because right now we are again at the point where we ask, well, what is now technical and what is not technical? There's still no definition. We now know that European patents are in the end only granted for the non-obvious technical contribution over the prior art. The control question is always, what does the software do? What does the innovation really do? Does it solve, what kind of problem does it solve? What kind of objective does it have? If it solves a technical problem, then we have good chances. Of course, the question technical or not technical, again, I said there is no definition in the law, and it's kind of a spectrum, of course. Everyone will have, let's say, a gut feeling of course, and kind of embedded software which controls the brakes in a car, for example. That is, of course, a technical software because it solves a technical problem that would be patentable. And on the other end of the spectrum, maybe if we have a piece of software that, I don't know, analyzes stock market developments, that would not be patentable because this kind of software does not address any technical problem, but a financial problem. So on the edges of the spectrum, I think things are pretty intuitive, probably. And we also have a lot of case law at the EPO. That's really the great thing about the European Patent Office, that they receive, I think, roughly 170,000 applications per year. A considerable amount of those goes on appeal then, and then we get the decisions of the boards of appeal on which we can orient ourselves. And many topics in the software field have already been decided. Of course, embedded software is perfectly patentable if it controls a technical system or a process. Think of self-driving cars, drones, robotics, industrial automation. Here, software that is embedded and that controls these kinds of processes or systems has no problem with patentability, unless it's non-obvious, of course. But we also have things that are maybe not so intuitively technical. Things like image processing is regularly considered technical at the European Patent Office. Think about face recognition algorithms, for example. We have language processing, like voice assistants.
Yeah. Can I ask to Claudio to mute yourself? Claudio Ferraro. Could you please mute yourself? Some noises are interrupting the sessions. All right, thank you so much. Please, Bastian.
Perfect, thanks. So these things are quite technical at the European Patent Office. Things like data coding, data compression, cryptography, if you are ciphering your data. That is pure math in the end. I mean, cryptography algorithms are pure mathematical constructs, but if they are applied for ciphering data, electronic data, they become technical. So many topics in the software field are already decided, and I would say at the European Patent Office, overall, it's pretty progressive. There are many fields which are patentable at the European Patent Office. One topic, of course, one trending hyper trend is, of course, AI and machine learning. And the European Patent Office even introduced a new section into the guidelines for examination. And when I read it for the first time, I was kind of disappointed because with AI, the European Patent Office has certain problems. They say that basically the whole computational models and algorithms underlying machine learning, the neural networks and things you might have heard of, the training methods, all of that is per se abstract math for the EPO and not patentable as such. So if you have a client who has invented a new kind of training method, so really an innovation in the core of AI, that's not patentable at the European Patent Office right now. What is patentable is applications of AI in a technical field. Let's look at some examples. So one example is, for example, an AI-based image classifier. And the idea here was to take training images for this image classifier. Normally, to train your machine learning classifier, you would need lots and lots of training data, which you sometimes do not have. So the idea here was to take one picture, training data picture, and duplicate that picture many times and change the parameters in a systematic way. So this classifier was about classifying scenes. So this classifier would look at the picture and say, well, there's a river and a boat on it and things like that. So it's a harbor scene. And you would now take a training picture and duplicate it and change, for example, the lighting conditions, or crop the picture so you get different kind of sub scenes. So you basically create many training images from one, and then you have more training images, and then you can train your classifier. That's basically what the claim says. We can skip that. And here in this example, the European Patent Office first refused the application. The applicant went on appeal, and the Board of Appeal then pretty much just compared the invention to the prior art and found that it was non-obvious, and in the end granted the patent without even discussing whether this would be technical or not. So this was considered a technical application of AI, apparently. Another example is an AI-based spam filter. That's a patent application by Microsoft. So you have this mail classifier which reads incoming email messages and then classifies them either as legitimate mail, goes to the inbox, or as spam, goes to the spam folder. So also some kind of classification, not for images, but for text here. And here the Board of Appeal said that no, this is not considered technical, because what the email classifier does is it looks into the content of the email and reads the text. And that is a purely linguistic exercise, not a technical one. And so here we have, I think, two examples where it gets really difficult to explain the person on the street what should be patentable or what should not be patentable at the EPO, because in the end, and it's also codified now in the guidelines for examination, image classification is technical and text classification is non-technical. So that's really difficult to explain when I talk to founders, to inventors. They want to tell me all the ins and outs of their new classifier, right? And how they tweaked it, and what are the cool things. And I as a patent attorney, have to say, wait, stop, don't tell me all the details yet, because it simply doesn't count for the EPO. We first need to talk about what are you classifying? Are you classifying images? Then we have good chances. Where if you're classifying text, chances are not so good. So that's quite, yeah. I think I'm a little bit disappointed that the EPO makes these distinctions. I only have 0 minutes left, so maybe can I have 1 more minute? Because I have to talk about G1 of 19, the landmark.
Minutes. No problem.
3 minutes. Wow, great. Thank you. Perfect. G1 of 19, the landmark decision everyone was waiting for in the software patents field. The decision itself was about the question whether computer-based simulations should be patentable. So if you have a simulation of a football stadium, for example, and how people walk through the stadium, and you can then see whether the emergency exits are big enough, something like that. Whether these purely virtual simulations without a physical input and without a physical output, whether something like that should be patentable. G1 of 19 made some interesting statements here. One thing which I appreciate is that the technical board of appeal, which referred questions to the enlarged board, was asking for a minimum requirement for technicality being a direct link with physical reality. So that would have meant that almost no software would be patentable anymore, because it would only be patentable if you either really measure something from in the real world, or if you control something in the real world, like a car or a robot arm. Here, the enlarged board says that there is no need for such a direct link with physical reality, but they also say that it's in most cases sufficient. So it's still, I think, an important factor that you have this direct link with physical reality to be on the safe side, at least. And this is also reflected in some broader considerations of the enlarged board of appeal. Here, they do not anymore talk about simulations, but about computer implemented inventions in general, so for any kind of software invention. And they say that, well, technical interactions can, of course, occur on the input side, on the output side, and within the process, so to say. But the only examples which they list in the decision are rather disappointing for me. They talk again about measuring something in the real world, about a control signal used for controlling a machine, and they talk about better using storage capacity or bandwidth. So really, in the end, they always seem to fall back to this physical world, you know, to this idea that technicality has to be tangible in some sense, and has to be in the real world. Which brings me to my conclusion now. So from a conceptual point of view, European patents are only granted for the non-obvious solution of a technical problem. So that's a pretty stable framework. The notion of technicality is quite progressive in many software fields. If we talk about cryptography, about database technology, it's perfectly technical for the EPO. So that's really, I appreciate that very much as a computer scientist. But also on the other hand, G1 of 19 shows that really the core of the notion of technicality is not very digital, is my conclusion. So at least the enlarged board of appeal still has this idea that technicality has to happen in the real world somehow. And I am convinced that we need a technicality conception which is more virtual, more digital, to take account of the developments that are taking place. But I guess it will take, the EPO sometimes still until they really digitize their technicality notion, let's call it that way. But that's up to us practitioners to fight for those cases. Thank you very much.
That was a great, very fast and very comprehensive presentation, Bastian. Thank you so much. And it was really interesting to see the difference between the image classifier and the text classifier from Microsoft case and the Intellectual Ventures case. So we have some questions for you. And before, okay, I'm muted. So we have questions from different countries. So I'm starting with the easiest one from India. Rohit Mishra is asking that, will you share the slides? This question is both all of the speakers.
For me, sure, of course, sure.
All right. The Barish also is willing to share, right? Maybe Mr. Gökap, will you?
Yes, of course.
All right. All right. Rohit, the answer is yes. So we will share from our LinkedIn account. So the question is coming from the Netherlands, from Mayank Singh. Is asking that, how is the word computer interpreted by the EPO? Is it essentially a hardware capable of processing operations?
Yeah, I think that's basically, so that also there is, I think, no comprehensive, really written down definition of the word computer. At least not that I know of, but yeah, I think the EPO interprets this very broadly. So it doesn't have to be a PC, a personal computer, or a laptop. Could be a smartphone, basically anything that has a processor in it and can process digital data.
And also Mayank is agree with your case that you shared regarding the image classifier. He also recommended. And Işıl Selen Denemeç from Turkey she's asking that, is there any technical difference between the meaning of computer programs and the software within the context of the European Patent Convention, or do they refer to the exact same scope?
Yeah, that's difficult to say because the term software or software patent really doesn't occur in the European Patent Convention. So it's not in the law, and it's also not really used by the Board of Appeal in the case law. The EPO always talks about computer programs, or if it comes to what is now the invention, they talk about computer implemented inventions. That's really the official term. So that's just an invention which at least one step of which uses a computer. That's what the European Patent Office really looks at. And they ask whether it is an invention inside of there. Mm-hmm. They don't really talk about software patents. Software patents is sometimes more used by let's say, the opponents of patents from the open source and free software community. So if we want to use the official term, it would be computer implemented invention.
All right. So the next question is coming from Daniel Ricardo Durango. He's asking that, how does financial rated inventions are considered by the EPO? Are they more difficult to proceed?
Absolutely, yeah, because as I said, so everything which really deals with the financial part is considered per se non-technical by the EPO. So if you would have a really sophisticated algorithm for analyzing the stock market fluctuations, let's say, and if the algorithm is so sophisticated that it really predicts very accurately how stocks will develop, it will still be considered non-technical by the EPO because it just deals with financial information. That's not technicality, and it will just be removed from the consideration by the examiner. So yes.
Kind of similar questions coming from Cahit Kayın from Turkey, and he's asking that, do you have any advice on how we can patent or non-technical software content?
Yeah, difficult. I mean, you have to try to make in your patent application the best arguments you can find. I mean, sometimes it's possible. Sometimes it's a question of from which angle you look at the innovation, you know. I mean, even if the original intent was to solve some kind of financial problem, maybe there is a technical clever thing in there somewhere. So sometimes that's the task to find it. And I mean, if there is none, then it's simply in the end not possible probably to get a patent in Europe, maybe in other jurisdictions then.
Exactly. So the question from Murat Örümcek from Turkey is asking to me that he couldn't find the Let's Turkey YouTube account because it does not exist yet. We will open it and share this video, and we will share to all our registered participants by email. No worries. So you will be aware when it is open. So also Daniel shared the Bastian's YouTube account, so you can also click on this YouTube account from Bastian Best. So he is sharing very valuable information about software patenting procedures. So, and also he is explaining very, the easiest way to understand. So this is a difficult topic, but he can convert these difficult terms into understandable words. So it is really advantage to follow him. So Bastian, thank you so much. So you're staying here. Maybe we can have other questions after the Mr. Gökalp's presentation. So we will spare another time to answer some of the other questions. Thank you so much, Bastian.
Thanks for having me. Thanks, Mustafa.
So we can continue with the Barış, and Bastian, please make Barış as a host because you are not now host.
I see. Okay. How do I do that exactly?
From the participants, you can find the Barış and click make host. So Barış, your slides are ready.
Okay.
All right. I think you are now host and you can share.
I have already shared. Can you all see the
Yes, we can definitely see. We can definitely see. So 20 minutes is yours and the stage is yours.
Okay, thank you, Mustafa. First of all, thank you for inviting me to this special event, and I'm honored to speak alongside with two well-known persons from Europe and the United States in our IP world. Let me briefly introduce myself. My name is Barış Atalay, and I'm in the profession for around 20 years and was qualified before the European Patent Office 10 years ago. I also act as an EPI tutor and CIP tutor, and my field is electrical engineering. Now, I better move on because I have a serious number of slides. Okay, let's start with the most relevant question. I will try to cover business methods practice before the European Patent Office today. And the most relevant question we can ask is actually, are business methods patentable? And the short answer is no, but of course we have a longer answer, and we will get into the intricacies of this right now. It's possible to, although much harder than computer implemented inventions, it's possible to also obtain grants for business methods, provided that they show at least one technical feature is a good candidate for solving an objective technical problem. Now let's start with the provision, Article 52 EPC, and we have three clauses here. The first one is actually making reference to the conventional classical patentability criteria, novelty, inventive step, and industrial applicability. But there is also, I will say, an implicit criteria here. Is not directly mentioned at all. It is the technicality. Bastian also touched upon that. And in the third clause, you see there is this little expression as such. Bastian also indicated, talked about this part. If we are patient enough to read until the very end part of this article, we see that the non-inventions as described in the second clause are excluded only as such, meaning that if we have something additional to add to the non-invention, for example, my topic is business methods. If we have a pure business method in the claim, it's a non-invention. But in the event that we have something additional, for example, a technical means, then it is no longer a business method as such. It passes the first test of Article 52. It is the, we can call it the eligibility test. And as an entry test, if we pass this test, we are facing the three remaining main criteria: novelty, inventive step, and industrial applicability. Also, it's worthy of mentioning that we have in Turkey the new industrial property law having the same identical wording for this article. Now, in case we are able to have a claim passing the technicality test, then we will, as I said, need to face the novelty and inventive step conditions, and we have to have a claim which is patentable and which is inventive, of course. But for that, we have to briefly look at the basic theory of the problem solution approach. Very basically, this blue rectangle represents prior art. We could say the closest prior art. And this orange ellipse is the differentiated features of the claim, the independent claim over the prior art. As you can see, part of the ellipse is orange, whereas the remaining part is blue, because the blue part is not novel. Okay. Now we have here some features. We call them technical features, but they are not always technical. A feature is something, I will say, I will call the smallest definition, a number of smallest definitions in the claims. We try to divide the claim into smaller definitions these can be structural or functional definitions or parameters, whichever. And we just study an inventive step based on these technical features. But the problem is that they are not always technical. As you can see, we have two red circles here. They are not technical, but the green one is a technical one. Okay. Now the problem is that we have to have an inventive solution to the objective technical problem. What is the objective technical problem? It is the problem defined without making reference to the solution itself, and it is identified such that a person skilled in the art is asked this question. This person, this fictional person, tries to answer, tries to reach the solution in the claim without having any prior knowledge of anything in the claim. Of course, the person skilled in the art is made aware of the blue rectangle because it's the close prior art, but he's not made aware of the orange ellipse. Neither was she made aware of anything in the claims, any technical features. Okay, so what happens next? If there is no differentiated feature, we cannot continue, we cannot pursue the problem solution approach because our strategy cannot be executed because the chain breaks right at this stage. If you don't have any green circle in your claim, in the differentiating part of your claim, you cannot continue from this point on because you don't have any differentiating feature with a technical character. Okay, now up to now we have seen that we have the technicality requirement, and if we satisfy the technicality requirement, we have the further requirement of novelty and inventive step. And for novelty, we need to have a technical, just one technical feature with a technical character, and we will then see if this is inventive or not. Now, referring to guidelines, G2 section 353, let's briefly see how the guidelines define business methods. This is the general information. I will go through this very quickly. Banking, billing, accounting, marketing, advertising, licensing, management of rights, contractual agreements, any activities involving legal consideration are of commercial and administrative nature. Further continuing, personal management, designing workflows for business processes, communicating postings to a target user community based on location information are examples of organizational rules. Okay. Further, operational research, planning, forecasting, optimizations in business environments, logistics, scheduling of tasks, collecting information. You see all of these using mathematical and statistical methods to evaluate information for the purpose of facilitating decision making. Still business methods, but as you can see, we have this Hitachi decision, the decision of the Technical Board of Appeal, T35804. Basically, its teaching tells us that if there is anything with a hardware in the claim, it could be anything, a desktop terminal, sensor, peripherals, whatever. In this case, we just satisfy the technical requirement. It's a low threshold requirement. Okay. Then it is not excluded. It's not considered as a non-invention under Article 52. I move on quickly. But in the event that we have this condition met, then we must satisfy novelty and inventive step. And in this case, we have the Convict decision. The Convict decision, T64000, tells us that the distinguishing feature, you remember the green circles? The green circles must be in the distinguishing part of the claim, and they must have a technical character solving the objective technical problem. Now, let's have a look at some examples to get into specifics. Okay. This decision is the application was refused by the examining division, and the applicant has appealed, but the appeal was dismissed under technicality. So let's briefly study the technical content of the case, if it is technical or not. There is a mail piece which was sent to be delivered to an addressee, but the addressee was not found at the given address. Upon this, the mailer steps in and tries to make a systematic search to notify the corrected address to the post office. This is the invention. Okay, this is the brief summary. Mail not delivered, notice from postal office. Mailer conducts search for the correct address, then mailer responds to the notice by the post office. So findings by the Technical Board of Appeal. First finding, delivery of a mail piece is something technical, something physical, because it's a real world thing, okay? Then it should be, sorry for the poor grammar here, it's my bad. It has to be regarded as a technical process. But since there is no mention of any hardware in the application documents, in the description, the board first considers that persons skilled in the art will inevitably come to the conclusion that the process should be carried out by a computer. But despite this, despite the Hitachi decision I was just mentioning about, the board, by the way, it's also worthy of noting that Hitachi decision is a very broad, brings about a very broad interpretation, because using a pen and paper is considered technical. To this extent the technical is taken into account. The board here notes the Hitachi decision, but indicates that possibility of making use of unspecified, because there was not any mention of technical means in the description. Noting the Hitachi decision, the board indicates that there is a lack of technicality. Okay, this is the second example. Again, the case was refused by the examining division, appealed, and appeal was dismissed under Article 52.2. In here, we have a method for scheduling tasks in an industrial refinery. This industrial refinery suggests that this is a technical process, but the board notes that placing of tasks in a timetable schedule or any other type of list for allocated resources is not technical, since the industrial refinery can still not be construed, not be interpreted to define any technical process with a technical character. Okay. The third example, here we have a test subject, such as a person, which is presented with certain orders, and the test subject makes selections to match orders with specific stimuli. For example, these could be visual or audio stimulus, such as, for example, a picture of a dog or a happy family scene, or an expensive car or sexy person. The test subject tries to match these orders with such stimuli. The board notes that the board disagrees with the examining division that it's a mental process, because it's not a mental process. It takes place in real physical world, because there is this test subject, the person, and she's presented with orders, and she's making selections. Okay, but the board states that the activity of claim 1 does not require means or measures of a technical nature. So no technicality. Moving on quickly, this is the final example. In here, there is a method for estimating sales activity of a product at sales outlets. This is the preamble, the introduction of the claim. we refer here to the Convict decision, the cornerstone decision T64000. The decision tells us that it is legitimate to have a mix of technical and non-technical features in the claim, but of course the non-technical ones, remember the red circles are ignored in assessing novelty and inventive steps. So lack of technical character here. Because creating information about sales activities or other types of business data using mathematical or statistical methods to evaluate data gathered from respective business environment is a business research. No technical problem solved at all. But let's not jump into making quick assumptions, because there was another claim in the auxiliary request during the appeal procedure, and in this case, like suggested in Hitachi decision, there was a technical means in the claim, but the technical means was not sufficient for rendering the claim inventive, because the distinguishing feature of the claim was the use of a known system for performing a new market analysis different from the calculations in the document, but this had to be ignored in assessing inventive step because had no technical character. So I finished my presentation by returning to the basic theory of problem solution approach. You see, if you pass for business methods the technicality test, you still have to have at least one green little circle here, which is technical one, can solve the objective technical problem, and which is therefore a candidate for building our inventive step. Thank you, Mustafa. It is the end of my presentation.
You finished before the 20 minutes.
Okay, I was too afraid to talk too much. Sorry.
All right. Thank you so much. So these examples are really comprehensive. So maybe I can turn to the audience if they have any questions while I am reading the previous questions for you. And Ismail from Istanbul, he asked and write a kind of funny and sarcasm question or remark. He said that I would encourage EPO to visit all the technical university of XYZ in Europe and convince PhDs that they are working on non-technical stuff. So thank you so much for your comment. It's a really good one. And Daniel from Colombia is asking that machine learning classifiers applied to reduce fraud risk in credit applications are considered technical by the EPO.
So I think Bastian should be addressing this question because it's outside the scope of business methods.
Bastian would like to consider to answer that question.
Sure, just very quickly. So this is actually a great example, I would say. You have a machine learning classifier, so some kind of AI technology, but it is used to reduce the fraud risk in credit card applications. So on the one hand, there are quite a number of cases, I would say, where the EPO has said that things that improve IT security are technical. But I think if we talk about credit card fraud, I think this is more considered non-technical by the EPO. I think I saw a decision that dealt with kind of this topic exactly. So I will look it up and will send it to you. I'll put it into the chat probably. I think there's an EPO decision already that said that fraud detection, if it focuses on let's say on the financial fraud, is non-technical. But I will get back to that.
All right. Maybe Barış, I can make a comment or a question. So you are practicing mostly in Turkey and European clients. So also I know that you are working with the startups, technology startups who are working on the software area. So what is the common question, or what is the common misunderstanding question coming from the technology startups about patentability of software and business methods?
Okay, it's generally something which cannot be easily conveyed as a as a piece of information to managers in startup companies that software is basically patentable, provided that certain conditions are met. These conditions are sometimes not easy to explain. As you can see, we have a number of cornerstone case law in Europe, and every invention, every single invention has to be taken into account by itself. So it's sometimes a hard task to see at the very beginning when you have your meeting with the client about the invention. It's not right away there to see which part of the invention is actually has a potential for grant before the European Patent Office. But generally speaking, clients are very reluctant to accept the fact that it is much harder to maybe not. It's not good to exaggerate to that extent, but it's harder to have grants for computer implemented inventions.
All right. Thank you so much, Barış. So also thank you for your timing.
Thank you, Mustafa.
So now we are going to do Las Vegas. So Mr. Gökalp Bayramoğlu will also cover the United States perspective on the patentability of software. And you can also ask your questions on the chat site while he's speaking, also after the slides. So Barış, could you please make Mr. Gökalp
Sure. I'm just
on the participant site, so you can just click on Gökalp and then...
Okay. Just a sec.
Yes,
just a sec.
So we have another 30 minutes, and we will use this 30 minutes with 20-minute presentation from Mr. Gökalp, and then 10 minutes for the question and answer from your side, from the audience, and then we will close the session. So we are going in a very good timeline.
Is it okay, Mr. Bayramoğlu?
Barış, maybe you can cancel your screen share, and then Mr. Gökalp can continue.
Okay.
Yes, now you can share, Mr. Gökalp.
I think I got it. Let's see.
All right.
It's coming.
Can you see?
Yes.
Yes, you can make it full screen, and then we can start.
Okay. Is it looking okay now?
It is not a full screen, but okay, it is fine.
Fine. Okay.
Yes, we can see that.
Good afternoon, everyone. First of all, Mustafa, thank you for setting this up, and of course the whole organization, LES, and thank you, Bastian, Barış, for your excellent presentations. I learned quite a bit today about how these applications treated at EPO. I see in audience there are several friends of mine and several clients and also several people I don't know. Either I know you or not. I send you my regards from Las Vegas, Nevada. With that, I would like to talk about software and business method patents. If you notice, I combine them together because in US, we don't have such a thing, software patent, business method, or technical, non-technical. We don't have anything. The patent right is put in the US Constitution, stating that anybody finds something useful, invention is patentable. Man or woman create anything under sun, patentable, provided that it meets the requirements of the law. Before I go any further, I would like to talk maybe 30 seconds or a minute about my firm and myself. Where Bayramoğlu Law Office is located in Las Vegas, Nevada. That's our headquarters. We have branch offices in China and Turkey in Ankara. We don't work with Turkish Patent Office. Our people in Turkey, they help us communicate with our clients there. We have about 55 employees worldwide, attorneys, agents, case managers, paralegals, and we are admitted in different jurisdictions in the US, including United States of America. I myself have a PhD in electrical and computer engineering. I'm a patent attorney. The question is, can I obtain a US patent for software business method inventions? Again, patents are not categorized as software business method, technical, non-technical. As long as it meets the requirements of the law, you can get a patent. The toughest requirement for this type of invention, software business method, is Section 101, which I will talk about that in a minute. Again, algorithms for computer programs, we call software. And when you go to US-EPO, try to get a patent for software algorithm, there are some little tricks you need to use in claims that to write, but that's our job as patent attorneys, that you know, stating like data structure, operated on computer processor, those sort of things. For example, for the data encryption, I would like to share with you that these are all different encryption algorithms I'm sure you heard of and came across. DES, Diffie-Hellman, public key crypto systems, and RSA. These are all patented at US-EPO, and if you look at the numbers, 4 million, they already expired, most of them. So that shows you that you can get a patent for software. The case law history, I want to give you quickly. The way it works in the US, we have US-EPO, and let's say you applied for a patent, examiner rejects it, then you appeal to board, and board either agrees with you or disagrees with you. If board sides with the examiner, you can take it to Federal Circuit Court. You move into the court system, because Federal Circuit oversees board's decision. And then if you don't like Federal Circuit decision, you can appeal it to Supreme Court, and then the Supreme Court steps in. All these cases I put here, and I started from 1972, these are all Supreme Court decisions, kind of shapes the field, how, you know, how you determine what is patentable, what is not patentable. For example, I won't get into every single detail of these cases, but if you look at Diamond versus Deere, in this case, it's a curing rubber, and you know, and adjusting the heat, how to cure a rubber, and it used a computer to calculate and control the heating times of the rubber. This was rejected by examiner at US-EPO, board at US-EPO, Federal Circuit even sided with US-EPO, but Supreme Court overturned their decisions, stating that this is patentable because it met the requirements of the law, and it was a practical application of the invention. So that's they said it's patentable. Again, in 1994, in Lowry, and then the State Street Bank, these are all building up together, and it came to Inra Bilski in 2008. This is the typical example of business method patent that was rejected by examiner and the board at US-EPO, and then Federal Circuit also rejected it. And the reason they rejected was it's a business method, and it went to Supreme Court, and the Supreme Court said, we don't categorize applications or inventions as business method or software or anything. We look at everything, every single invention, and then determine if the invention and the claims, of course, meet the requirements of the law. That's always what Supreme Court stated. And that was, and they still rejected patentability in Bilski, but for different reasons. They said it was an abstract idea, and it didn't pass the test of abstract idea, which I will discuss in a minute. And then there was Mayo Collaborative Services and Prometheus Laboratories in 2012, and that was also a doctor following certain protocol to administer the dosage of the medicine that was found not patentable under Section 101. And finally, in 2014, Supreme Court rendered the decision on Alice Corpman and CLS Bank International. This is the case law we use. This is the latest one that tells us how to do two-step analysis to find out if an invention is patentable or not. Again, I get back to the question, can I obtain patent in the US, software or business method invention? You can obtain patent in the US for anything. It doesn't matter, technical, non-technical, as long as you meet the requirements of these 4 sections of the law. Section 101, patent eligibility. Section 112, definiteness, enablement, written description requirement. Section 102, novelty, and Section 103, obviousness. And of course, the first hurdle is Section 101, which I will get into it in a minute. And I already mentioned that the ALICE, the software related to software decision by the Supreme Court. So patent eligibility is determined by 2-step analysis. Any invention, you put it into, you think about this as a machine, you put it in, and then it spits out it's patentable or not. Of course, it's not that easy. There are so many considerations, as you will see in a minute, that basically it is a 2-pronged test. The first prong is the claim a process, machine, manufacture, or composition? If it is, and then software in that sense considered process, business models, methods, they are considered process. And usually it's easy to go through prong number 1. And then the prong number 2 is, it used to be if there's an inventive idea applied to practical application. But USPTO, under the latest director who left, Iancu, they changed that a bit, and they made prong 2 in 2 separate sections. Prong 2A, prong 2B. In 2A, you determine if there are steps in the claim that makes claim if there is a practical application, even if it's an abstract idea or law of nature. If there is a practical application, then you could pass this test. So again, prong 1, under step 2, if there is we call it judicial exception, that's the buzzword. And so here, if no exception, then it's eligible. If there is exception, then it's not eligible. Exception being abstract idea and mathematical equations, those sort of things. And then prong 2, evaluate whether the claim recites additional elements. Let's take a look at here. Let me go to this slide. Grouping of abstract ideas, mathematical concepts, mental processes, certain methods of organizing human activity. And let me tell you, one of the issues we face when we deal with Section 101 rejections at the USPTO, you know, when examiners say this is a mental process, then the way the mental process is defined is that basically it's not practical to do this in your mind. If you have 2 machines involved, you are a software, but you're using these machines, you can't do this, even though when you look at the algorithm, you may think that you can do it mentally. In reality, it is not. So what we try to show is it's not practical to do it mentally. And of course, it changes from examiner to examiner. We have about 9,000 examiners now at USPTO. Some of them, they know the law very well, they follow, some of them don't. So that's where the challenge comes in. And that's why we need to know our stuff very well to be able to deal with it and help clients. So then, prong 2 considerations, some of the examples that are indicative of integration into practical application. For example, improving the functioning of a computer or to any other technology or technical field. It's a very easy way to do it. If you are improving computer speed or reducing memory requirements, things like that, that's a slam dunk case that there is no issue there that you'll get a patent. But then some other software areas where, let's say you are doing a simulation of seismic activities in an area, and what we'll look at there is that what are you doing with the result? Are you taking the result and are you applying the result to some to advance the technology, or are you providing progress in that field? And also, if you take the judicial exception, which is an abstract idea, for example, and you are using it with a particular machine, then that's important. at the end, it all comes down to that USPTO and of course public, they want to make sure that you're not using abstract idea, you're not claiming such a way that you're excluding everybody else from the field, because they're giving you monopoly for 20 years for a utility patent, and they want to make sure that your claim is limited to your invention only. You're not excluding everybody else unnecessarily from the field. And also, when we're doing the step 2A analysis, we want to make sure that well understood routine conventional WURC activities, they are also considered, because all these steps in a claim, they're considered together, helping each other. A combination of these steps, how they work together to provide improvement into that field. Because sometimes we see examiners that, you know, they may reject a claim based on, oh, this is well understood routine conventional. Well, but the issue there is that in step 2A, under the new guidance from USPTO 2019, that those should be considered to determine the patentability or eligibility, patent eligibility of the claim. Again, the improvements, if the claim integrates judicial exception into practical application, then you need to consider if the functioning of a computer or any other technology or technical field. It doesn't have to be computer. It doesn't even have to have a hardware for that matter, but you need to show some improvement. And this is more on the 2019 PEG, stands for Patent Eligibility Guidelines by the USPTO. And this is more explanation on prong 2A. Now, prong 2B is the old step 2 determined by the Supreme Court in Alice decision. That is, if claim as a whole amounts to significantly more than the exception itself, the claim is eligible. I mean, you go figure. What does that mean? And again, this is why all of our attorneys and you know, courts, federal circuit and board, they try to figure it out. And so basically, it is very similar to 2A, but 2A is easier to get over than 2B. And the reason the USPTO came up with new patent eligible guideline, IENCU's, the prior director's mentality, as I understand, was let's not spend too much time on section 101 patent eligibility. Let's go to section 102 novelty, section 103 obviousness, and let's look at those. And let's not exclude those people who work very hard to come up with you know, software, business model, whatever. And if they are contributing to the field, consider them as patent eligible. So they kind of made the test a bit easier. And here I'd like to respond to, I know Ismail Ari, you said that, you know, if you go ask PhDs working on their stuff and you tell them non-technical, they will feel bad. I can understand that very well. This is why I think the system here in the US, no matter what you work on, as long as you meet the requirements, you can get the patent. And again, I saw a question from Daniel Ricardo earlier. He said the financial related, are they considered technical, non-technical? Again, in the US, there is no such a thing that, you know, technical, non-technical. It's it just needs to meet the requirements of the law. Resources, these are resources I listed here. You can go in there. And MPP is Manual Patent Examining Procedure. This is similar to examination guidelines at EPO. And it basically tells the examiner what to follow and tells our agents what to do in a prosecution. And then the other materials there. I have two examples here, but one of them is software related. The other one is business method. I don't think I have enough time to go through both. I'm looking at my watch here.
Please, we have.
Oh, okay, great. So let me go through the first one, adaptive monitoring of network traffic data. So basically, this is a network connected to internet, and what the current system does it monitors and finds abnormalities. Well, actually, it monitors the network and stores the whole network activity in storage here on the right-hand side. That's what the current system does. But what the inventor, applicant came up with network appliance, which has a software in there, and monitoring the network activity. And then when it sees abnormal activity, it started recording network activity. So this way, the storage reduced, and the communication with the storage device reduced, and there is an improvement into the system, and in turn into this field. So the claim for the for this invention is a method for adapting monitoring traffic data. I won't read everything there. And then I want to emphasize 3 steps. One is collecting traffic data, and again, by the network appliance. What is the appliance? It could be a hardware, or it could be a specific hardware, doesn't matter. And there is software there doing this monitoring and collecting, and then comparing it with a threshold to see if there's an abnormality or not, and then collecting additional traffic data if there's an abnormality. So it's not recording all the network traffic. Now, when you look at this, the steps that I went through, step 1, step 2, A, B, that's what we're going to do here. In step 1, does this claim fall within this statutory category? Yes, it does, because it's a process. It has to be either process, machine, composition, and any one of those. And this is a process. It goes through steps, so it is considered patent eligible and passes the step 1 test. And the step 2A, and what are the specific limitations, and if they fall in the groupings of abstract idea, collecting, comparing, and collecting. 3 steps there. And let's take a look at in our chart here. Is that a mathematical concept? No. Is that a certain methods of organizing human activity? No. Is that a mental process? Yes, it is, because you can do collecting and comparing with threshold, and communicating and collecting network communication. Although one can argue that how can you do that all that in your mind? But theoretically, it is possible. So then we say claim precise a mental process, but we don't stop there. That's not the end of the game. Now we go to step 2A. Step 2A is, are there additional elements that will make it such that we're not monopolizing in this field? And we are, and this is a practical application. Then we go to next slide here, and we're doing collection, we're doing comparing, and then we are collecting additional traffic data. This is where this last limitation really gives us the ability to state that, okay, my invention is limited to me, because, and then whatever I do with the network monitoring, it's helping me to do a better and more efficient network. So that's why I'm going to go through this quickly. And the claim is eligible because it is not directed toward abstract idea or any other judicial exception. That is because step 2A, there's a practical application. The practical application is to reduce the storage amount, to reduce the navigation, so therefore it's eligible. What would happen if we did not have that last element in the claim? I'm sorry, Mustafa, I think I'm going over a little bit. Is that okay?
Maybe we can skip the second example, maybe because we have 5 minutes left. But the first example was great. If you don't mind, we can stop and you can say the last sentences.
Okay, let me say 1 more minute if I can have.
Sure,
I want to complete it.
Of course.
And without the third element here, if you see, this is collecting network data, comparing it to threshold. And then if you remember in the claim, we had also collecting network data based on abnormality. We don't have that step here. And if you go through the test here, I won't go into every single detail, but when you go to the end, you will see that this is a mental process, and also there are not enough steps to make it like there is no practical application here. So we reached the claim that the claim is directed to abstract idea because basically you haven't done anything with what you compared. You collected data, you compared it, but you haven't done anything. So those are the important steps you have to go through. And let me go through here and say, this is the other example I won't go through. Method for transmission of notifications when medical records are updated. This is a business method, and you can see the details in the presentation we will share with you. And oh, one last thing is, I want to answer Bastian's question. That is one of the law firms in the US stating that EPO hostile towards AI patents. I wouldn't use the word hostile, but I would say the biggest difference between EPO and USPTO is that USPTO, because of the upper courts putting pressure on them and overturning their decisions, there is no such a thing, as I said, like software patent, business model patent. As long as you meet the requirements of this, the law set by Supreme Court, you can get a patent. Thank you so much for your time, and I'll be happy to answer your questions.
That was really great. So the examples are really comprehensive. Maybe did you answer the Daniel's last question, Mr. Gökalp, regarding the Alice's prong, or can I read?
Yeah, let me see. Let me look at.
All right, I'm just reading the Daniel's question from Colombia. Do you consider that Alice's prong 2 is an easier to overcome with technical character arguments, as would be useful for the EPO objections?
I wouldn't say, yes, of course. Anytime you have a hardware or specific hardware, when you're talking about the software or business model, it will be easier to overcome than not having any, than having a general hardware. If you have a specific hardware, yes, it is easier. But keep in mind that I wouldn't really look at Alice step 2. Instead, I would look at EPO guideline. I mean, as far as getting the patent from you, I mean, USPTO guideline, as far as getting patent from USPTO, that because their step 2, they broke it into 2A, 2B. So when you follow 2A, it's easier to show the practical application of the invention under USPTO guideline than using Alice. But of course, USPTO guideline generated based on the Alice. I mean, USPTO cannot come up with their own idea out of nowhere. They have to stay within the law, because if not, it's going to go back to Federal Circuit or Supreme Court. They're going to, slap on their wrist, and they're going to come up with, new decision, and they will overturn them. So that is what is different in the US also, that we have a court system. We can go up and then finally go to Supreme Court, that 9 judges, they look at it and they determine.
And maybe before closing the session, there are maybe the other participants can write down their questions in the chat section. So I can ask my question, Mr. Gökalp. What do you suggest? As well as we have already discussed this question in our podcast session that we recorded together last year. So what do you suggest to technology startups, technology SMEs who are trying to export, who are trying to enter the United States market with their software-related technology, in terms of the infringement risks, in terms of the licensing, in terms of patentability? So the US market is really challenging. It's not easy to success, because all the giant companies are really enforcing their patent portfolio. They are cooperating with each other in joining the different patent pools. So it is really hard to be alive in the United States as a market. So what do you think about the Turkish technology providers before entering the US market?
Sure. Well, actually, it goes for any company from Turkey or other parts of the world coming to US. I think there are two parts there that these companies, they need to pay attention. One is if they develop software, for example, and applying for a patent and getting the patent and going through all the requirements, as I mentioned here, especially Section 101 hurdle, that's number one. Number two is, regardless if you get a patent or not, you want to make sure that your product is not infringing upon somebody's patent. So that's why it's important to do kind of a search, and it can be a very extensive search, it can be a quick search, whatever, but at least look at it. And if you identify patents with claims that may be similar to your invention, then it's or similar to your product, then it's better to go analyze it to make sure that your product is not infringing upon the patent of others. As you know, Mustafa, having a patent does not give you the right to make a product or software or whatever. Having a patent gives you right to exclude others from using your software, technology, your invention in their product. So those are the two steps. One on the prosecution side, getting patent. The other one is and doing what we call it the freedom to operate. And everyone on this call, I'm sure they're familiar with it. Those are the two things that need to be done.
Yes, exactly. Thank you so much.
Sure.
So on behalf of LAS Turkey, and I would like to really thank you all of our speakers today who are sharing very comprehensive information with their presentations. But before closing the session, a last question from the Turkish participant, Işıl Selen Denemeç. So maybe she is addressing the question to Mr. Gökalp and Mr. Barış Atalay, both of you. What are the most critical points for the licensing of software patents? That's the last question.
Barış, you want to take that first?
I will say, of course, the requirements as stipulated in the contract, and these all depends to financial setup between parties, and also we have to look into the strength of the claims on which we base our IP. So this question can have two sides. One leg is the purely legal side, how we determine those conditions on the contract, and the other side is the power of the legal power of the scope of claims, I would say.
Yes, and also maybe the licensors and the licensees are really need to be careful about the royalty rate ranges before signing this transaction agreement, because if you're talking about the software patents, there are so many pools, right? So the question is also going to the standard essential patents if you're talking about the software patents, because most of the SAPs are in the software and the ICT sector. So this combination of the patent portfolios are really critical to define the package royalty rates. So maybe I can also comment on this question.
And I would like to add one thing to what Barış and Mustafa said, especially for US. When you sign a contract for software licensing, or for that matter, any technology licensing, I want to say the most important word you want to check is notwithstanding or notwithstanding, because in this contract, attorneys use that a lot, and they list everything on top. Let's say clause number 1, 2, 3, 4, 5, and then 6 says, notwithstanding anything discussed above, none they introduce a new term, meaning that everything else discussed 1 through 5 means nothing. So watch for that word.
Exactly. So I think we completed our job. So answering the question, the last question is the end of our mission. And Mr. Gökalp, Mr. Barış Atalay, thank you so much for your participation. I think the Bastian has left, and we will share your presentation slides by PDF because you have your permission to share. And also I would like to all the participants from different countries, Colombia, Netherlands, United States, India, and also as well as the Turkey. And We would like to see all of you as the speakers and as the participants in our next Friday IP Talks events. So greetings from Istanbul and have a nice weekend. Thank you so much for your attention and participation.
Thank you, Mustafa. It was a wonderful event.
Thank you so much. Bye-bye.